Chair Galloway, CPC 228-17. Maybe I should back up a bit and say that I put these on the non-consent agenda based upon my review and my listening to the entire case review committee. It didn't appear that there was a consensus, so I thought it better to err on the side of having them on the non-consent agenda so that they could be considered fully by the board. So starting with CPC 228-17, the complainant went to a substation to complain that her son, who suffered from mental illness, was released from the detention center and he had not been heard from since post his arrest. He was arrested for domestic violence. She also alleges that she was given certain assurances that he would get mental health. Help. This case has been administratively closed because in the review of the lapel videos and the fact that this was a domestic violence arrest, which was mandatory at the time. The woman alleged that she was struck to unconsciousness and she lived with the son. This was a mandatory arrest. As for his release, that does not fall under the purview or the jurisdiction of the Albuquerque Police Department, so therefore it was administratively closed.
Chair Galloway, I thought that I asked to have this on the non-consent agenda, so, but I will respectfully disagree, and I'll give you the reasons why I think it should be sent back. I won't vote to approve this. The introductory paragraph leaves out the fact that the email, the citizen complaint, was sent on Saturday, July 1st, 2017 at 9:37 p.m. The investigator wasn't assigned until December 19th, some 6 months later. And that's a violation of the city ordinance where we're to begin immediately after the complaints are filed and to proceed as expeditiously as possible. By not reporting that fact that the email citizen was sent that early fosters questions regarding the transparency on the part of the CPOA and the POB. As far as the complaint, I'm going to, for the benefit of the people that are in the audience or people that haven't read this, I'm just going to go through it briefly. Donna H. submitted an online complaint about how an incident with her adult son was handled. Mrs. H. went to the substation seeking help because her son struck her the previous night. That's what's in the complaint. The investigator, this is a comment, the investigator wrote a memo to the Police Oversight Board Policy and Procedure Subcommittee identifying portions of SOP 219, Response to Behavioral Health Issues, that need to be rewritten and revised. In that same memo, the investigator expanded on the domestic violence incident and stated her son struck her several times, prevented her from leaving the house, and seeking medical attention or calling the police. And now tonight, you have added the fact that he struck her and knocked her unconscious. None of that is in any of the reports. None of that is in the CPOA report. Now back to her complaint. Mrs. H explained her son had mental health problems. Mrs. H wrote the officers assured her that if she filed the complaint about the battery that her son would be placed in jail on the mental health side. Mrs. H wrote she was told her son would be evaluated for 3 or 4 days and appropriate action would be taken. Mrs. H wrote officers told her that her son would be safe and in jail until his hearing in July. Mrs. H was upset because what actually happened was very different. Her son was arrested, but did not have his phone or wallet with him. The jail released him less than 24 hours later and dropped him off on a corner at 2 a.m. with nothing. This is what she said in her complaint, but that's not in this part of the complaint in the CPOA report. All we have had is lies and non-caring on the part of APD. Then she wrote this, Mrs. H wrote, APD has done nothing to assist her in finding her son. Then this is written in her complaint, but not in the CPOA definition of the complaint. When my daughter from California called APD, she was told that they don't look for adults unless there are mental problems. We keep telling them that, but nothing is being done. If I knew this was how you were going to handle it, I would never have signed the complaint. That sounds to me like a complaint about the police department, not about MDC. The investigation now. This starts out by saying the CPOA investigator reviewed the police report and the lapel videos of the incident. It doesn't say what officers or what lapel videos. There's no indication in the CPOA investigator interviewed the complainant during this investigation. No statement about that. Now that may be because it's 6 months later before they got the case. Mrs. H came to the substation and reported a domestic violence incident with her son from the previous night. Nothing about the being denied access to medical services, being denied access to leave the facility, being knocked unconscious. Officers were very concerned for her safety, took her statement about what happened, and had a victim's advocate respond to assist her. The officers explained the victim's advocate would assist her in obtaining an emergency restraining order so that Mr. H, her son, could not return home to commit more violence. The officers broached the subject of restraining orders because they wanted her to be safe when her son was released. Excuse me. This raises questions and answers none, like did the victim's advocate provide any assistance? Was an emergency restraining order obtained and filed on the son? And then the statement is this is the investigative report. There was no specific talk of keeping him in jail until July. What kind of talk was there, is my question. Mrs. H expressed her son had nowhere to go when released, so another officer mentioned there were shelters and halfway homes her son could stay at while applying for services. The report says the sound was poor on many of the videos, but as best as could be heard, there were no specific promises made as to what could happen. The preponderance, this is my comment, the preponderance of evidence burden is not imposed on any party to a civilian complaint, but instead rests with the investigative agency. The poor sound of the many of the videos and the statement that as best as could be heard, there were no specific promises suggest a possibility that if the complainant may have been just as she claimed, assured if I filed a complaint, he would be placed in jail on the mental health side, he would have been evaluated for 3 or 4 days and have appropriate action taken. And she also said he would be safe and in jail until his mid-July hearing. The investigative report says any such promises would be unlikely because whether someone is released or held up is up to the judge and the jail process, not APD. This statement, this is my comment again, this statement supports a judgmental conclusion in favor of the officer's claims over the complainant's statements, and her statements are the heart of the complaint against APD, and some of her statements appear to be compliant with APD's SOPs cited below. Where did she get that information? Now, when officers took Mr. H into custody, he did not have property on him and did not request anything. The report doesn't say when the officers took Mr. H into custody. Were they the same officers to whom Mrs. H had made her complaint? And what were the charges? Was she present when he was arrested? The investigator's memo to the Policy and Procedure Subcommittee stated that SOP 219-85C5 states, if the individual is not appropriate for jail diversion, the officer should ensure that the individual is referred to the Psychiatric Services Unit within the detention center by writing PSU referral at the top of the pre-booking slip. The question is, did the arresting officers do this? And there's no way to verify this on the form without getting a copy of the physical form from MDC. But in the letter to the POB, it says, in this case, MDC Records Department was uncooperative. What does that mean? And if they were important enough that we tried to get them and they were uncooperative, why didn't we follow through and get them? The next SOP states that when officers take a prisoner to the Metropolitan Detention Center and have knowledge of a prisoner who has some kind of behavioral health disorder, they will notify the Metropolitan Detention Center medic, who can then notify Psychological Service Unit, PSU. The officer will forward a copy of the offense or incident report to the CIT Area Sergeant Coordinator. My questions are, did the arresting officer have knowledge of the son's mental problems and prior suicide attempts and thoughts of suicide, and did they notify the MDC medic? The COP report is silent on that issue. The issues of Mrs. H wrote about concerning her son's release are the issues with the jail and not APD. I agree with that. Arrest in persons, placement in jail, and how long they're here is outside of APD control. Again, though, did APD notify MDC of the son's mental state the night before, because they were aware of it, and when they arrested him? She writes that they did nothing to help her when she reported her son missing, but officers took a missing person report and entered him in NCIC. The question is, when her daughter called from California, she was told that they don't look for adults unless they have mental problems, and the question is, what are the APD SOP requirements when a reported person is claimed to have mental problems, even though they're 21 years old? The cause of Mr. H arrest did not fit the criteria for jail diversion. Okay, in conclusion, the CPOA has made the decision to administratively close the complaint as Mrs. H concern about how the jail handled her son's brief incarceration and release is outside of APD's control and therefore outside the CPOA jurisdiction. My question is, what about resolution of the complaint of allegations about what was told to the complainant by APD, and what about the APD arresting officer's compliance with SOP 219 elements cited when booking the son? Administratively closed complaints may be reopened if additional information becomes available is a statement that's on the bottom of some some CPOA reports, but it's not on all, and it's not on this one. As I said earlier, there is more information in the memo to the CPO, to the Police Oversight Board, on the fact that her son struck her several times, prevented her from leaving the house, seeking medical attention, or calling the police, which I think is a significant issue. She also says that she hasn't seen, at the time that she wrote the complaint, she hadn't seen her son. I just think that this is a wholly insufficient investigation. I really disagree with your, I think, limited conclusion that it's just an MDC problem. And I'm not going to vote for it. I'm going to vote to send it back to you guys to find out what's going on.
Just for clarification, Member Larson, what were the dates of the event, and then the follow-up by the CPOA?
The date of the event was July 25th or 26th, 2017. The report was filed on July 1st of 2017. An investigator was assigned on December 27th, 2017. And I think Director Harness and I have discussed several of these kinds of cases with the time delay, but this case with a lady who is missing her son seems particularly egregious to me, and that's why I took the board's time with this.
One other question, and that is, you mentioned, at least I heard, Policy and Procedures Subcommittee on a couple of occasions. Was that accurate, or was that?
Of course it was accurate. It's a memo in the file, but I believe it probably wasn't sent because it hasn't been approved yet. That's my guess. But it's dated March 28th. It's to you and Eric Cruz, Member Cruz, and Director Harness. And on March 28th, I was still on the board too. But anyway, thank you.
I think that my experience in the human service arena and with the police department over the last 3 years is that the pain and suffering of family members of people with mental illness is very real and very difficult. And there are limited to no resources in this community to deal with them, which hamstrings the police in a very serious way. It hamstrings the whole community in a serious way, but the people who are left to deal with these issues are the police. And I think the policies, which Mr. Larson referenced, are very clear in what to do. I have no way of knowing that any of those things were done. And so with the caveat that there are moms out there with sons who are, children who are adults and have mental issues that are frustrated in the extreme and want to have solutions presented to them, and their only avenue is the police department. I understand all that. It doesn't mean that this particular case, was investigated the best way that it could. So I think it's incomplete. I think that Mr. Larson is correct, that it's incomplete. There may be other issues having to do with the delay. As a committee member for case review, I want to know why it took 6 months for this to get to an investigator. And I want to know why some of the things, Mr. Larson did a great job of explaining what his concerns are, and I agree with them. So I think my suggestion is that this be not put forward and sent back to the staff to complete the investigation and answer Mr. Larson's questions.
Is that a motion?
Yes.
Member Fine? Do we have a second?
May I address?
Yes, absolutely.
Thank you. Chair Galloway, members Larson, and members Fine. As we have discussed on numerous occasions, we did have a system that was not efficient for the intake of our complaints as we were trying to resolve them in an informal basis. I have had that discussion with you several times, and I thought that that was understood. With our caseload, there are going to be investigations that are not done within the time parameters. So those will be violations of the ordinance. As it relates to this case, I stand behind the investigation. The investigative file is for review. It is available. I think it's hard to reach conclusions such as Member Larson has reached without looking at the investigative file and without looking at the entire portion of the investigation. So I believe that the case should be administratively closed and stay as it is.
Chair Galloway?
We have a motion. Do we have a second so we can
I would
continue
like to
discussion?
respond. Yeah, I'll second the motion, and then I'd like to just respond.
Please do so.
It wouldn't be any question if the investigative report was written like an investigative report or a CPOA report would be written. You explained to us several times that, gee, we made mistakes, our caseload, all of these reasons. As far as I'm concerned, I'm tired of hearing those reasons. And you signed the letter, so you have to stand behind them. But I think it's a wholly insufficient report if I have to then go read the investigative report to come back with these things. And your decision to not put the date that the complaint was filed, it really troubles me because it's not a factual, transparent report. And I think it highlights several problems with a lot of these reports. For example, the rest of the non-consent cases, I think, are going to have to be tabled because Chelsea is the one that was pushing those, and she's not here, or Ms. Van de Vinder. But I'm seriously concerned about this, and I don't accept your statement and criticism that I didn't go look at your investigative file. It's not my job to go look at your investigative file. It's your job to adequately reflect what was done in the investigative file in this report. And my opinion is you didn't do it. And your name's on it, so you're the one that's responsible.
Chair Galloway, Member Larson, I disagree that it is not your job to look at the entire investigative file, because that is exactly what's detailed in the ordinance, if in fact you do not want to follow the findings. So this is a findings letter. It is not the entire investigation. It is not the entire investigative file. Secondarily, I have described to you the new efficiencies that we've put in place so that there is not a delay in the cases any longer, and that has been in effect since March 1st, and I have told you that repeatedly.
Okay, gentlemen, I think that we have had our say. Is there any additional discussion on this case?
The intent was the motion was just to not vote on 228-17.
I think it was not to allow it to go forth, not to allow this finding letter to go forth to the complainant. Is that correct?
Because we see it as incomplete.
Okay.
And I will take the middle ground here and say that I think that the complaint did specify very clearly some APD issues as well as the MDC stuff. So I would take a vote then, all in favor of moving this letter forward and allowing it to go out to the complainant. Aye?
Well, I have a motion on saying that this should go back to the staff, so we should have vote on that.
So then we'll word it that way, to a motion to have this letter go back to the staff for further investigation.
Yes, because the board sees it as incomplete.
And is that what you seconded?
Yes.
Member Larson? Okay.
Yes.
That motion on the table, all in favor?
Aye.
Aye. Any opposed? Great. So Director Harness, if we could get some answers on those APD complaints as well, and a new findings letter, that would be appreciated.